So once again, good morning. Today we meet with Miss Yulia Anosova, who holds her PhD degree in international law and who works as a lawyer at a non-governmental organization La Strada, Ukraine. And today we are going to speak about trafficking in human beings. The topic of today's online lecture is countering human trafficking in Ukraine according to national and international standards, general context, and new challenges posed by the war. And I pass the floor to Yulia. Please, Yulia, if you would like to say anything, not only about the topic, but about your work in general, please, you can do so. If the participants of today's meeting have questions, please, you can write them, you can put them into the chat box. You know how to use it, or raise hand and ask Yulia directly. So Yulia, are you expecting questions during your lecture or after?
I would say that there will be opportunities to pose questions during lecture, but all the main discussions will take part after the lecture.
Okay, so Yulia, please, the floor is yours, and I will mute myself.
Thank you, Ms. Olga, for introducing me. I'll maybe clarify a little bit more about my background and my work in La Strada, Ukraine. So my name is Yulia Anosova. I'm currently working as a lawyer at the civil society organization Anosova, Ukraine. It is a Ukrainian national NGO. It is based in Kyiv, so our main office is in Kyiv. And for more than 20 years, we work in such fields as countering human trafficking, countering gender-based violence, in particular domestic and sexual violence, protecting children's rights, peace building, mediation, and other related areas. We do lots of advocacy work, awareness raising activity, monitoring activity, and also we run two hotlines, National Hotline on Prevention of Domestic Violence, Human Trafficking, and Gender Discrimination, and National Hotline for Children and Youth. I should mention that the topic of human trafficking is especially current during this time, during war. And as example, I can say that on our hotlines we receive more and more requests from people who have to leave Ukraine, refugees, and also internally displaced people in Ukraine who ask us lots of questions, including concerning how to avoid risks of human trafficking. So this topic is very important, especially now, and I will try to touch upon not only the international standards which are active in times of peace, but also the ones which somehow relate to the situation of war. So I will start to share my presentation. Please, Ms. Olga, tell whether you can see it or...
Yes, I can see it.
I could try to make it full screen. Is it full screen or?
Yes.
Okay, perfect. Okay. So let's start with finding out how much you know about human trafficking and whether maybe some of you heard about or can name any international instrument which concerns with the issue of human trafficking. Please, if anyone can answer, comment. Are you familiar with any instrument on human trafficking? Okay, then.
Just the one of the United Nations Convention against transnational organized crime. We did it in transnational law.
Okay, and how this convention is related to human trafficking? Does it cover human trafficking?
Yes, it does cover human trafficking because I remember it's like more like the only or like the first legally binding instrument which was made internationally that recognized what human trafficking was. It also provided a definition concerning it.
Okay, great. It's wonderful that you shared about it. We will talk about it in a few seconds. Maybe anyone knows about European instruments? Okay, so we will discuss it shortly.
Yes, Council of Europe Convention. We also studied.
Okay, so you already studied it, yes?
I mean, there was mention of it, yeah, but not like study. Mention.
Okay. Okay, we'll try to discuss it in details now. So concerning universal treaties, it was mentioned in United Nations Convention against transnational organized crime. Yes, there is such convention, and this convention has 3 protocols. First protocol concerns illicit manufacturing and trafficking of firearms and other weapons. Second protocol concerns smuggling of migrants by land, sea, and air. And third protocol, which chronologically actually was adopted as first one. It is the protocol to prevent, suppress, and punish trafficking in persons, especially women and children. So to clarify, there is United Nations Convention against transnational organized crime as a central instrument. However, the issues of human trafficking are resolved, established in the protocol to prevent, suppress, and punish trafficking in persons. And also, I should mention that also we are discussing it now as the most relevant and the most modern, up-to-date international instrument. Before that instrument, there were many other instruments adopted during different time in 20th century, starting from the beginning of 20th century, which concerned with the issues of slavery. However, as it was correctly mentioned, the first definition of human trafficking, as we know it now, was provided in this protocol. So the protocol to prevent, suppress, and punish trafficking in persons, especially women and children, was adopted in 2000 and entered into force in 2003. It was adopted in the city of Palermo, and that's why its second name, unofficial name, is Palermo Protocol. And it defines the crime of trafficking in persons. Before discussing further, I should mention that we use interchangeably different terms, such as human trafficking, trafficking in persons, trafficking in human beings, but essentially they mean the same thing, just in different international instruments, different variation of this term is used. So we mean the same things when we are talking about this. Trafficking in persons means recruitment, transportation, transfer, harboring, or receipt of persons by using such means as threat or use of force or other coercion, abduction, fraud, deception, abuse of power, or position of vulnerability of a person, or giving payments to another person to achieve this person's consent to trafficking. And this is done for the purpose of exploitation. In this context, exploitation means and includes at a minimum the exploitation of the prostitution of others and other forms of sexual exploitation, forced labor or services slavery, or practices similar to slavery servitude, or the removal of organs. So it's basically a definition, verbatim definition from the Palermo Protocol. If we break this definition into parts, we see that basically the actus reus, or the action of crime, it consists of 3 elements. So in order to be classified as human trafficking, it needs to be there needs to be present an action which can consist in recruitment, transportation, transfer, harboring, or receipt of persons. So the list of these actions is basically exhaustive. Also, this action should be committed with the purpose of exploitation. And we saw that in a definition what actual exploitation can mean, and also this action is done not in any way, but using a means, certain means, and this means include threat or use of force or coercion, fraud, deception, abuse of power. So basically the exhaustive list of means which should be used in order to constitute human trafficking. And if we are talking about an adult person, an adult victim of human trafficking, it is irrelevant whether this person gave his or her consent if the means were presented here were used. So, for example, a person could consent for being trafficked, for being recruited or recruited or transported. However, this person was forced to, was made to give this consent by use of force, or the traffickers used the position of vulnerability of this person. So whether there was or was not a consented person is irrelevant as far as the means were used. However, if we are talking about child victim, that is a victim who is under age of 18, even if a child consented and the means listed here were not used, it is immaterial. So for a child, in order to constitute crime of human trafficking, we need only two elements: action and purpose. No means are necessary. Okay. Then and also I want to if you since we are talking about Ukrainian context as well, we will try now to compare international standards with Ukrainian legal provision on human trafficking. So how these international standards were incorporated into Ukrainian legislation. So the crime of human trafficking is defined in the Criminal Code of Ukraine, in particular in Article 149. I tried to make a translation on my own, so it's not official translation, but my own, and I tried to reflect the definition as accurate as possible. So the crime of human trafficking is called verbatim. It's called sale of human beings in Ukraine. So we do not use a term which literally means trafficking, but we use term which sounds like a sale of human beings. So Article 149 defines human trafficking or a sale of human beings as a sale, as well as recruitment, transportation, harboring, transfer, or receipt of the person for the purpose of exploitation by using coercion, abduction, deception, blackmail, the abuse of economic or other dependency of the person, or a position of vulnerability, or giving of payments to achieve the consent of a person having control over another person for that person's exploitation. So if now we compare this definition with the definition from the Palermo Protocol, first of all, we see that there is additional action, which is sale, as well as all those actions which are listed in the Palermo Protocol, such as recruitment, transportation, harbor and transport, or receipt of persons. We see the element of purpose as well, so the purpose of exploitation. And we also see the list of means by using coercion, abduction, and so on. So the list of means actually a little bit wider than in Palermo Protocol, but basically the definition, overall the definition corresponds to Palermo Protocol, except for this additional action of sale. And why do we have this, how do you think, why do we have this additional word for like additional action of sale? Any ideas? Okay, it's a tricky question, so I'll try to answer it. So basically, if we are talking about human trafficking, English word for trafficking, it means, if you are thinking about what it means some sort of moving into space, like transportation, like movement. Trafficking corresponds to movement of person. And here we use sale as a sort of transaction. And it since actually this term, sale of human beings, and this action of sale was preserved from earlier version of Article 149 since 2000, from the time of adoption of the Criminal Code of Ukraine. Back then, Ukraine did not incorporate the definition of Palermo Protocol, and the definition which was adopted in 2001 in the Criminal Code of Ukraine was even more differed even more from the definition of Palermo Protocol, and you can see it on the screen how this crime was defined in 2001 before 2006. So it included only basically only transaction, so sale or other illegal transaction, and no element of trafficking as we see it now, like recruitment, transportation, harboring, and so on. So like in the definition before 2006, we had a very I would say outdated definition of human trafficking. And this definition was based on earlier instruments, which I mentioned earlier, international instruments, which defined what is now called human trafficking. And those definitions concerned more state of slavery than trafficking in what we see now. So sale, basically a transaction which is done over a person, corresponds to sale, corresponds to slavery and slavery-related practices more than, for example, modern definition of human trafficking, which focuses more on the element of basically transportation of moving person from one place to another place. Also, coming back to the definition, current definition of Article 149, so current edition of this article, we see that this article also defines the means of exploitation of a person, and this list of means is, if you compare this list with Palermo Protocol, it is much wider. So, for example, apart from sexual exploitation, slavery or practices similar to slavery, labor exploitation, it also includes such, I would say, novel forms of exploitation, such as removal of organs, experimentation of person without consent, forced pregnancy, forced abortion, forced marriage, forced involvement into begging, recruitment into criminal activity, as well as exploitation in the armed conflicts, which is very topical issue now. And apart from being wider, this list being wider, it is also non-exhaustive. As we saw in Palermo Protocol, the list of grounds for exploitation is exhaustive. However, in the definition of human trafficking in Ukrainian legislation, the list of grounds for exploitation is not exhaustive. Do you have questions so far about definitions and elements? Okay. Yeah.
It's clear.
Please.
The students say that it's clear.
Sorry.
As far as I can hear, the students say that it is clear for the time.
Okay. Okay. Perfect. Then we will go to another aspect of Palermo, of the definition in Palermo Protocol. Remember, I told you that Palermo Protocol is one of the three protocols to the Convention against transnational organized crime, and it has its consequences since it's not independent international instrument, but basically part of this convention. It has some limitations. So Palermo Protocol can be like the whole convention against transnational organized crime, as well as its protocols, and also Palermo Protocol can be applied only if the crimes which we defined above, so the crime of human trafficking, if it is transnational in nature, and if it involves an organized criminal group. So basically, if human trafficking occurs within the territory of one state, Palermo Protocol does not apply to this type of crime. So it needs a cross-border element. And also, another thing is that this crime should be committed by an organized criminal group. So if this crime is committed by a separate individual person who acts in individual capacity, this is not human trafficking. Also, in practice, these crimes are so need such level of organizations that they are mostly committed by organized criminal group. However, in this case, it is a requirement of Palermo Protocol that there should be organized criminal group involved in this crime. If we come back again to Ukraine, to the definition of the human trafficking in Ukrainian legislation, we see that there is no requirement of cross-border element, so it can be national as well as transnational crime. And there is also no requirement about who should perpetrate it, whether it should be individual person or organized group. If we, again, like some historical remark, if we look at the definition before 2006, we see that this definition had a cross-border element. So this crime had to be committed involving transportation of a person through the state's border of Ukraine. But now it's not the case, so human trafficking can be national as well as international. And I should mention, by the way, that during COVID pandemic, when the borders were closed, we had a rise in cases of human trafficking, which were committed nationally. So before COVID, most of the cases were international, but during COVID, due to closed borders, there was increase in number of national human trafficking in Ukraine. So now, when we look further into Palermo Protocol, we see that apart from definition of what human trafficking is, the protocol sets a number of standards of the protection of victims. So now we are talking not about like just some technical aspect of definition of a crime, of establishing obligations of the state to criminalize this crime in national legislation, but we also see the set of standards, minimal standards, the state should ensure to protect the victims. Since Palermo Protocol was adopted quite a long time ago, the number of standards is not that long. However, there were subsequent developments in law which concretized the standards and widened its list, the list of the standards. However, in Palermo Protocol, we see like the basic set of standards, which should be ensured to protect victims. And I named here only a few of the standards. So, for example, they include ensuring confidentiality of information about victims. So when state is working with state authorities work with victims, they should do everything possible in order to not making personal details of a victim be disclosed, because otherwise it would be a breach of personal life of a victim as well. It can be dangerous because victim can be in a danger that human traffickers will revenge her. So state should provide confidentiality of any information about victims. Also, state should provide physical, psychological, and social recovery of victims. And this standard presupposes a number of concrete actions, such as providing victims with appropriate housing, providing counsel and information, including about legal rights, also providing medical, psychological, and material assistance, providing employment, educational, and training opportunities. So these are all the measures which are needed in order to restore some functionality, I would say, of a victim in society after the crime happened. Also, the standards include ensuring possibility of obtaining compensation for damage suffered and adopting measures to permit victims to remain in the state's territory temporarily or permanently in appropriate cases. Here we are talking about cases when victims, when it's cross-border human trafficking, when the victim from one state found herself or himself in the territory another state where he or she were trafficked, and they need some opportunity to stay on the territory of this another state in order to, for different purposes, for example, for criminal proceedings against traffickers, for restoring his or her functionality, and so on. So the state should provide opportunity to remain on its territory for at least for some time. Okay, so is there any mechanism for implementation of Palermo Protocol? Have you ever heard about mechanisms for implementation of Palermo Protocol? I assume that maybe someone heard, but it's actually quite a new mechanism, and it was not incorporated into the protocol itself. So the protocol was adopted in 2000, and the mechanism was established in 2018, and it was established not by any additional instrument, but by resolution of a conference of parties to the United Nations Convention on Transnational Organized Crimes. So it's sort of unusual, I would say, unusual way of establishing this mechanism. And this mechanism is quite unusual itself, because for international law, it's quite a new format. And it's called, like, it was foreseen in the resolution 9.1 adopted in 2018 by the Conference of the Parties of the UNTC. And it was called mechanism for the review of the implementation of the convention. Actually, the word implementation of the convention is pretty strange, because it's more about, like, okay, it's review of implementation, but basically it's monitoring of how this instruments are implemented, because by monitoring, because actually so far as they put in this resolution, they do not have much I would say influencing power over or recommendatory power on how states should implement the recommendation of this mechanism. So this mechanism was launched in practice in December 2020, and it is called peer review mechanism. It presupposes that states, each state party reviews the implementation of UNODC and its protocols by another state party. So that is why it's peer review. So there is no special committee which does this review, but each state reviews another state. And in the core of this mechanism, they put the review of according to 4 thematic clusters. So basically what was done, the convention on transnational organized crime and 3 protocols, each of these instruments were divided into 4 parts, thematically, 4 thematical parts, and each part addresses includes provision which addresses different aspects. For example, if we are talking about Palermo Protocol, it has different provisions in different articles which can be united under such topics as criminalization and jurisdiction, prevention, technical assistance, protection, and other measures, law enforcement and judicial system, international cooperation, mutual legal assistance, and confiscation. So each of these thematic areas is reviewed by each state reviews another state's implementation of this every of these areas, and every area is reviewed for 2 years. So, for example, if the mechanism was launched in 2020, the first thematic area, which is criminalization and jurisdiction, will be reviewed till 2022. So 2 years for first, 2 years for second, and so on area. if you're talking about Ukraine, the states which review how Ukraine implements the convention and Palermo Protocol are Poland and Fiji. So Poland and Fiji will make reports on how Ukraine implements the Palermo Protocol. And Ukraine will make reports on how such states as Lithuania and Gabon implement the Palermo Protocol and the convention. So each state, this mechanism determined pairs of states which review each other. So I hope that it's pretty clear. I'm trying to to put it as concrete as I can. But if you cannot understand, you can clarify. And actually, what concerns Ukraine, the reviewing process over Ukraine started in 2020, and it should finish by December of 2022. So we expect in the end of this year the reports by Poland and Fiji on how Ukraine implemented the Palermo Protocol. How this country reviews are used. So the reports prepared by countries will be submitted to the general review by the Conference of the Parties of the Convention and the protocols. And this Conference of the Parties will develop recommendations, will decide on how to better provide technical assistance to states with implementation of convention and protocols. So far we do not know how much how obligatory these recommendations will be, but again, judging by the model of how this mechanism was established, these recommendations are not very do not have very much obligatory powers for states to implement. But again, it will be decided in the future. Now. Let's move to another instrument, that is Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW Convention. Why this relevant? First of all, it has specific provision which concerns the issue of human trafficking, and this provision is actually Article 6 of this convention. And Article 6 foresees that states should take all appropriate measures, including legislation to suppress all forms of trafficking in women and exploitation or prostitution of women. Actually, I should mention that this convention was adopted much earlier than Palermo Protocol. It was adopted in 1979. And apart from this provision, there is no more specific provisions in the convention itself on any aspect of human trafficking. However, it is relevant, first of all, because currently, if we are taking, coming back to Ukrainian crisis, Ukrainian war, more than, according to the United Nations, more than 90% of Ukrainian refugees living in Ukraine are women and children. And if we are talking about human trafficking, we should also understand that it affects differently women and men, and we should be gender sensitive in applying any trafficking, human trafficking provision. And convention, CEDAW Convention, as the convention which focuses on women's rights, is extremely relevant in these circumstances, because it takes into account different aspects of how human trafficking affects women. And another aspect is that, as adults, the convention was adopted more than 40 years ago, and since then, the CEDAW committee, it's the committee which supervises the implementation of the convention, which its mandate includes issuing the general recommendations. So the committee basically possesses the right to interpret provisions of the convention. And so far it adopted nearly 40 general recommendations. So general recommendations are documents which interpret specific aspects, specific provisions of the convention. And these recommendations, basically, they are not obligatory. do not possess this obligatory power, which possess, for example, specific provisions of the convention. However, they help to interpret this provision, and that's why they are very relevant when states are trying to implement these provisions. So Ukraine is a party of CEDAW Convention, as well as Russia is a party of CEDAW Convention. And in 2020, one of the last general recommendation of the CEDAW Committee, it targeted specifically this provision of Article 6 on human trafficking. And this recommendation was titled Recommendation on Trafficking in Women and Girls in the Context of Global Migration. So we are talking here not only about migration as voluntary migration, but also different crises, including war crises where there are refugees. So basically this recommendation is talking about human trafficking in the context of different global crises, including conflicts. And one of the sections of this recommendation concerns specifically the situations of conflict and humanitarian emergencies. And it clarifies that the obligations under the CEDAW Convention, which states have, they do not cease in the periods of states of emergency, including conflicts. And also it says that trafficking in women and girls is exacerbated during such periods, during period of conflicts. And this is because not only like direct military actions, but also because of displacement of people, because of these military actions, actually. Also because of the breakdown of political, economic, and social structures of the state, because of the normalization of gender-based violence, including conflict-related sexual violence, as an aggravating factor of pre-existing discrimination against women. So basically what it is talking about is that war situation, it exacerbates all the problems which were before the war with human trafficking, and affects in a very negative way the situation of human trafficking, and not only in within the state where conflict takes place, but also in other states where refugees can flee. Or where people from one state can be displaced, for example, as is happening with Ukraine and Russia now. And also this recommendation offers a number of steps, a number of obligations that states have concerning human trafficking, in especially during situations of conflict. I did not provide these specific obligations, but you can read this general recommendation. It's very interesting, and like the obligations of the states are detailed in a very much like are very detailed there. So I would recommend to read the whole recommendation, and including the parts, of course, on the conflict, but also other parts which establish the general obligations of states concerning human trafficking situations. Are there any questions so far? Okay, good. You can put them in the chat, or prepare them to the end of this lecture. Okay, so another instrument, as was mentioned before, the European Instrument on Human Trafficking is the Council of Europe Convention on Action Against Trafficking in Human Beings. It was adopted in 2005, and it, as well as Palermo Protocol, it sets a definition for human trafficking. They call it trafficking in human beings, a slightly different term, but as I said, it means the same as trafficking in persons or human trafficking. So it defines trafficking as recruitment, transportation, transfer, harboring, or receipt of persons by means and for the purpose of exploitation. So we see the same number of actions, the same number basically of means, and also the same number of grounds for exploitation. And as well as in Palermo Protocol, the number of the list of these grounds for exploitation is exhaustive here. However, it says that exploitation at minimum includes these grounds. So it means that at maximum, the grounds can be this list can include other grounds because international law develops and forms of human trafficking develop, and there may be other forms of purposes of exploitation. And to name just an example, comparing the definition in Palermo Protocol, in Council of Europe Convention, in Ukrainian definition, definition in Ukrainian criminal code, there is no such ground for exploitation as exploitation for surrogacy or involving surrogacy. However, this is a novel form, I would say, of human trafficking. We are talking about not just surrogacy as a term, as a state of affairs, but putting surrogacy or regulating surrogacy in legislation is not in itself regulating the grounds for human trafficking. We are talking about abusing surrogacy for purposes which are exploitatory, so basically exploiting surrogate mothers. And if we are turning back to the CEDAW Convention and General Recommendation 38, actually, when there was discussion of this general recommendation with civil society, some organizations, including Ostrada Ukraine, they offered the CEDAW committee to include such exploitation ground as abusing surrogacy in the list of grounds for exploitation, and this form also was included. So even though it's not listed here directly, it means that it doesn't mean that surrogacy or any other new ground for exploitation cannot be included into this list of the convention or into practice. So if we compare this definition of the Council of Europe Convention with definition of Palermo Protocol, so basically the definitions are the same, but the conditions for use of these definitions are different. As I told, Palermo Protocol depended on the Convention on Transnational Organized Crime, so the crime had to be transnational and committed by organized criminal group. However, since the Council of Europe Convention is independent international instrument, it does not include these requirements of transnational nature or organized criminal group. So trafficking persons can be committed by a separate person and can be committed internally, so without crossing the border, according to the convention. If you're talking about again, standards of the protection of victims, as well as in Palermo Protocol, the Convention, Council of Europe Convention lists a number of standards for protection of victims. However, this list of standards, since the convention was adopted later than the Palermo Protocol, it's much wider and it's more concrete. And apart from the standards of the Palermo Protocol we saw above, it includes the number of standards include, for example, assistance, like obligation for a state to ensure assistance in criminal proceedings against offenders to a victim, and also ensure access of a victim to education for children. So not only education for a victim itself, but also for his or her children. Apart from this specific standards, we are talking also about other standards. We will discuss them in a few seconds, but before I should mention that Council of Europe Convention specifies that assistance to the victims, so all these kinds of assistance to the victims, they should not depend on whether victim cooperates with law enforcement. So if whether victim reports the crime to law enforcement or not, the victim has a right to receive assistance, such as housing, such as legal support, such as education for children, such as material, psychological support, and other kinds of support. So the state should not make this assistance dependent on readiness of person to cooperate with law enforcement. Ukrainian legislation has the same provision, so the assistance to the victim does not depend on whether victims reported the crime to the police. However, it's like there is like a provision as a principle. However, into practice, it is not always easy for a person to receive any assistance unless this person received an official status of a victim of human trafficking. And this is like not another, I would say, another impediment to receiving this assistance, which should be in principle, according to this Council of Europe Convention, unconditional of any reporting of the victim to state authorities. Another important standard which is set in the Council of Europe Convention is so-called recovery and reflection period. This standard presupposes that when a victim was trafficked into another country, that country has to give this victim at least 30 days when this victim cannot be expulsed to the territory of another state. So basically, in most cases of human trafficking, we are talking about illegal stay of people in another country, and immigration authorities, they usually act as prescribed, doing expulsion of the illegal immigrants, as they deem, to the territory of the state where they came from. However, when we are talking about victims of human trafficking, when there is a suspicion that a person became a victim of human trafficking, the immigration authority cannot just enforce any expulsion of such person, at least within 30 days. And that is the period which is needed for a person to take a decision whether he or she wants to participate in criminal proceedings. So we are talking about restoring of functionality of a person and giving him or her an opportunity to think about whether to engage in criminal proceedings or not. If we are talking about Ukraine, so basic Ukrainian law on human trafficking, like apart from definition in the criminal code of Ukraine, Ukraine has a specific law which is called on countering of human trafficking. And this law sets some standards on protecting victims of human trafficking. And one of the standards this law attempted to implement from the Council of Europe Convention is the standard of recovery and reflection period. However, it was not implemented comprehensively, and instead of unconditional permit of a person to stay for at least 30 days, we have so-called permit for a person to stay for a period during which the application of a person on establishment of a status of a victim of human trafficking is considered. So we are talking here about another impediment. So in order to stay in a country officially, a victim of human trafficking needs to submit official application to state authority and ask them to establish your status of victim of human trafficking. And this application can be considered up to 30 days. And that is how Ukrainian authorities consider that they implement the standard of recovery and reflection period from the Council of Europe Convention. But if we compare the standards, we see that in the convention, the standard is unconditional, and in Ukrainian legislation, it is conditioned on whether the person submitted this application or not. So it's not fulfilled to the fullest extent in Ukraine, and like international community criticized Ukraine for not completely implementing this recovery and reflection period standard. Another standard from the Council of Europe Convention is a residence permit, and it presupposes that the state should grant the victim of human a residence permit which can be renewable, and the granting of this permit depends on one of the two circumstances or both of these circumstances. So if a person needs to stay on the territory of state because of the personal situation, or if a person needs to stay on the territory of state for the purpose of cooperation in investigations or criminal proceedings. So we are talking here about two grounds for granting this residence permit for a foreigner who came illegally to the territory of state. If we compare this to Ukrainian legislation also foresees the possibility for granting this residence permit, but only under one of these conditions, which is condition B, that is, if a person needs to stay in order to cooperate with investigation authorities, the person can be granted this permit. Again, Ukraine was criticized for not implementing the standard of residence permit fully in its legislation because there may be different circumstances of why victims of human trafficking needs to stay in the territory of state, and this can be like varying circumstances related to personal situation. For example, the need to reunite with family, the need to I don't know, like plenty different circumstances which need to be there should be a possibility to consider other circumstances as well, even if a person does not report the crime to law enforcement. Other standards from the Council of Europe Convention is, for example, the obligation of a state to ensure free legal aid for victims of human trafficking. In Ukraine, unfortunately, there is no specific provision on this standard. So there is provision on that state authorities provide person with legal support, but it is not determined that this legal support should be free. If we look in other legislation, not legislation specific to human trafficking, for example, law on provision of free legal aid, there is a list of categories of people who can receive this free legal aid. However, victims of human trafficking are still not in this list. For many years, different organizations and even some state authorities support the inclusion of victims of human trafficking into this list of persons entitled to this free legal aid. However, it was not successful. I don't know why, because basically it does not, this category of victims is not that big, the number of these people is not that big, and it does not take much state resources to include these people into this list. However, for some reason, this category of people is not in this list yet. Another standard is compensation for victims. And Convention of Council of Europe Convention determines specifically of what this compensation could mean. And it determines that it means, for example, establishment of a fund for victim compensation. So meaning that a state should establish a special fund from which victims are compensated directly for the suffering they endured because of human trafficking. Or otherwise to establish special programs aimed at social assistance and social integration of victims. And this fund, again, it's what offers the Council of Europe Convention, that this fund can be filled through, for example, property or profits confiscated from human traffickers. So it's not the state who should allocate some budget for filling this fund, but it's state who should organize confiscation of property of human traffickers in order to fill this fund. If we are talking about Ukraine, there is no specific provision on any fund for victims, which would compensate them, like any state fund, which would compensate victims. We have some provisions concerning, for example, providing victims with one-time material award, which is currently around $200 US, and also the provision on possibility of victims to ask for compensations in civil proceedings, meaning that in order to gain a compensation, victim has to initiate separate civil proceedings and ask the court to confiscate, to compensate this victim from the property of the offender. However, these standards, these provisions on, I would say, compensation of victims in Ukraine, like the models which Ukrainian legislation now provides, it does not correspond to the standard of the Council of Europe Convention, because it, if we are talking about civil proceedings, they depend on totally on the initiative of a victim, and so far I do not know about any successful, like there were some trials, but there are like very few, like few victims received compensations throughout like all the history of independent Ukraine, compared to the like thousands and tens of thousands of victims of human trafficking, which were established. So it's very negligent percentage of victims who receive such compensation. And if you're talking about material award, it's more about material support, and it's not about compensation as such. So if you're talking about compensation, it must be independent of the initiative of victim, like independent of any court proceedings, and it should be a fund which is created and managed by state. So far, Ukraine does not fulfill this standard as well. Next standard is so-called non-punishment provision. It's a very important provision in the Council of Europe Convention, because there is no such provision in Palermo Protocol, and it is a next step into protection of the rights of victims of human trafficking. It's not about, I would say, assistance to the victims, but more about ensuring their like legal rights as victims of human trafficking. And this standard presupposes that each party should provide for the possibility of not imposing penalties on victims or for their involvement in unlawful activities, to the extent that they have been compelled to do so. So here we are talking about victims of human trafficking who were involved in the criminal activities. So they were exploited for some criminal activities, but they were exploited because by using the means which we were talking about. So for example, they were forced into criminal activities, or their position of vulnerability was used to involve in unlawful activities. And in Ukrainian context, we can talk about there was a number of cases, and even some of these cases went through La Strada, when there was a number of Ukrainians who were offered job in Russia, legal job. And when they came to Russia, they were forced into drug trafficking. And they were forced, they were threatened. Very often their position of vulnerability was used in order to involve them into this criminal activity. And then they were, Russian Federation, the law enforcement, they arrested them, and there were trials, and they were imprisoned for substantial sentences. For many years sentences, and obviously Russia does not have national legislation non-punishment provision, as well as Ukraine. Ukraine unfortunately did not implement the standard as well. However, like in practical manner, if we are talking about this case between Ukraine and Russia, there was some practical aspect which is very problematic, still very problematic, and that is the aspect of how like people who were imprisoned, Ukrainian citizens who were imprisoned in Russia for drug trafficking, Ukraine took efforts in order for these people to be transferred to Ukraine to serve their sentences in Ukraine. And according to the terms of this transfer of Ukrainian citizens from Russia to Ukraine, the punishment, the sentences in Ukraine should be like the same as it was in Russia. So, for example, if Russia sentenced them for like 8 years in prison, when they are transferred in Ukraine, to Ukraine, they should serve 8 years in prison. However, if Ukraine would implement this non-punishment provision, which does not allow to punish victims of human trafficking, it is still like legal dilemma on how this the provisions of like terms for transferring of these people to Ukraine and this provision of non-punishment would correlate, would interact, and whether Ukraine would have grounds to relieve these people from prison because of this non-punishment provision. However, it's only theoretical because first of all, Ukraine did not implement this non-punishment provision yet, and secondly, if Ukraine would implement it and would release prisoners, in practical terms, there is an issue of concern whether Russia would transfer these prisoners to Ukraine in the first place. Now it's not that relevant like in terms of war. However, like before the war, it was very like a big legal dilemma for Ukraine as well. So the Council of Europe Convention has monitoring mechanism. This mechanism is incorporated into the convention itself. And this monitoring mechanism presupposes the existence of two bodies. First is a group of experts on action against trafficking in human beings, or so-called GRETA. And this group of experts, it supervises, monitors how each state implements the provision of the convention. Then it adopts a report on what it monitored and what it observed, and also conclusions on how the state implements. However, GRETA does not prepare recommendations on this report, and recommendations are prepared by the committee of the state parties to the convention. And these recommendations, obviously, they have recommendatory character. However, since this mechanism is a part of convention itself, it is stronger, I would say it's stronger mechanism than if we compare to Palermo Protocol, because it's part of the convention, because of the authority of, for example, of committee of the parties, because this is a committee which consists of representatives of all the state parties. So it has more, like I would say, more influence on how the states will implement these recommendations. If we are talking about Ukraine, so far there were 2 rounds of monitoring of implementation of the convention by Ukraine. The second round took place in 2018, and GRETA adopted its report. The committee of the parties adopted their recommendations, and you can look at this report and recommendations at the website. I have a link if anyone will need it. I could share the presentation after the lecture, so there is a link to this reports in English. And also, since we are talking about the situation of war in Ukraine, I hope I have some time to highlight some of the aspects of correlation between human trafficking in times of peace and times of war. First of all, in theoretical terms, actually, I was asked several times about whether actions, whether international crimes which are done in Ukraine now they include human trafficking and how like international crimes defined in the Rome Statute, they correlate with human trafficking, and in particular the provisions of the Palermo Protocol and the Convention, Council of Europe Convention. And I looked a little deeper into this topic actually, and found out that, for example, if we are talking about Rome Statute of the International Criminal Court, it has like one provision, one crime which is most closely correlates to human trafficking as we define it now. So this crime is called enslavement, and this crime is included into the section of as a crime against humanity in the list of crimes against humanity, and also enslavement. In this list, there is no like terms that enslavement including human trafficking in the list of official list of in the Rome Statute. However, when there is like a definition of enslavement, official definition in the Rome Statute, they it is like defined as it can include human trafficking. However, the problem is that in order to be classified as enslavement, human trafficking has to be more severe than as it is defined, for example, in Palermo Protocol or Council of Europe Convention. What I mean by more severe, so we were talking about human trafficking involving different grounds for exploitation, and we listed those grounds as, for example, slavery or forced labor or sexual exploitation. And in order to be classified as enslavement, the exploitation of the ground for exploitation in human trafficking should be more like slavery, so more grave ground of exploitation. And also there is another issue which complicates the classification of human trafficking as enslavement under Rome Statute, is the fact that enslavement is a crime against humanity, and in order to be classified as a crime against humanity, it should be committed as part of widespread and systematic attack, and also be a part of the organized state policy. So if we are talking about human trafficking, like in conventional sense, it is mostly committed by organized group, so group of basically of criminals, of individuals. And here we are talking about enslavement is about basically organized state policy. So the perpetrator should be state or otherwise such a group which is organized in such a way that it controls part of the territory of a state. So we are talking here about very serious organizational level for enslavement, and we are talking about very serious form of exploitation of people. So human trafficking is the correlation between these two crimes is also shown on the slide. It's like they can intersect. However, they are at the same time, they are two separate crimes, but in some aspect and in some circumstances, they can intersect, of course. And again, if we are talking about Ukraine, it's so far I did not see like the signs that would give ground to classify any actions committed related to human trafficking by Russian military to be classified as enslavement. But again, it's before any investigation, before any determination of the court, it's very hard to say whether there are such serious forms of enslavement in Ukraine that would allow them to classify them as an international crime. And also my last remark is about practical influence of the situation of war on human trafficking in Ukraine. So if we are comparing peaceful times and times of war, of course, we are talking about increased vulnerability of victims to of people generally, and especially of women and children to the situation of human trafficking, because they compared to peaceful times, many victims' homes are destroyed. there is a much bigger economical instability, victims lost their jobs, there is imminent threat to life, and they move abroad for getting into safe place. So we are talking here not about the purpose of going abroad to earn money, but about going abroad to save their lives. So it makes them much more vulnerable than in ordinary times. And also there is increased danger to children because actually from my observation as a practitioner, currently children are transferred through borders without proper documentation, and it is not always easy to trace the fate of these children who are transported through borders. There is no order or algorithm of how border authorities would register these children and trace where they go after they cross Ukrainian borders. So there are much heightened risks of children, especially to get into situations of human trafficking once they get through Ukrainian borders in European states or in any other states as refugees. Also, in times of war, we are talking about positive obligations of states under the specialized conventions, under the Palermo Protocol, under the Convention, Council of Europe Convention. So we mentioned certain standards of protection of victims. We also mentioned that states have some obligations to prevent human trafficking, investigate it, and prosecute offenders. And also to establish international cooperation. So we are talking here about positive obligations not only of Ukraine, but also of other states, including European states, who accept, who welcome the refugees. And especially this aspect of international cooperation, I would like to highlight it because like international community criticizes some European states that from the first weeks of war and even now, they did not establish any comprehensive mechanism of cooperation on how to especially register people, especially children. As I mentioned, children are not registered properly. And there is no enough cooperation between law enforcement of different states to trace the risks to the victims of human trafficking and also to trace, to investigate the cases of human trafficking, like across borders, in particular concerning Ukrainian refugees, because it's a big group and it has a particular risk, and there is no special mechanism targeting this particular group of people. And also another important thing which is worth mentioning is that in situation of war, the work of courts, the work of law enforcement, social service, medical facilities are disrupted in the territory where there is a war, and they're oriented to more urgent needs. And here also a couple of examples. For example, before the war in Ukraine, there was a center for rehabilitation of victims of human trafficking, the only center in Ukraine, and it was run not by government, but by NGO, actually by International Organization for Migration. However, since during war, state authorities do not register that many cases of human trafficking. The center was reoriented to rehabilitation of victims of sexual violence and not like putting all capacities into helping of victims of human trafficking. That is basically all I wanted to say. I don't know how much time we will have for questions, but I will gladly answer all the questions you have.
We have 3 minutes, but we also have 10 minutes of break, so we can use a couple of minutes from that time. So dear colleagues, do you have any questions, comments on what you have heard from Ms. Yulia Anosova, please? do not hesitate to ask questions or to comment on the issue of human trafficking. Yes, Victoria, please.
Yes, good morning. I wanted to ask because I saw documents regarding it, but it's written a lot about it, about the consent of human trafficking. If usually the general rule, obviously, you should not consent to slavery, to force, some force measures and so on. However, there are some, I noticed there are some cases when people can agree. Is it considered as a crime then, especially in forced labor issues? Is it considered then as human trafficking or not, or it's irrelevant? Because usually it's, I've noticed it's written that it's irrelevant. However, there are cases where it can be relevant, the consent or not. Is it true?
Thank you for the question, Victoria. It's a very interesting issue. As I mentioned in my presentation, formally, the consent is irrelevant so far as one means of exploitation was used. So we are talking here about threat or coercion or fraud or using of position of vulnerability. And exactly this last round, using the position of vulnerability, is very tricky one because usually the court establishes all these elements, and the victim should prove that he or she was in such position that could be classified as position of vulnerability, and that he or she had to consent. It's not that easy to prove. However, usually, it depends on the court to weigh this consent issue over the vulnerability, whether this vulnerability was enough to justify the not application of this consent issue.
Yes, so I understood the element, because obviously a person can be under stress, can be, the circumstances can force a person to consent and to do something. Or what if it was not vulnerable, it was just agreed to it? This person is so desperate to just agree to it.
Well, it depends why this person is desperate. So, for example, it might be some sort of psychological threat, some psychological pressure by perpetrator. And again, we should look whether it can be classified as fraud or deception or a threat or like different. So why this person became so desperate in the first place?
Okay, thank you. It's clear. Thank you.
So any other questions? The chat box is empty, no questions there. So and no other hands raised, which means that everything was clear. Congratulations. Thank you, Julia. Thank you very much. And I say goodbye to the students, and I will make a picture because we have new participants with cameras on. And the picture should be nice. Okay, once again. So dear students, goodbye, and I'm turning off the recording.